I have the utmost respect for Judge Velaki. I think today, though, the Commonwealth's case was extremely thin, and while they're entitled to inferences, even at this stage, I understand we're doing a preliminary hearing. However, I think they still fell woefully short of their burden. The evidence was very simply put that there was a shooting that took place, and perhaps Mr. Scott was involved in the shooting. And that's really all the uncontradicted evidence as far as today goes. The problem that I have with bounding him over for court for first-degree murder is that the attendant circumstances, the record is completely void of the attendant circumstances involving the shooting, which I think is the piece that you need. That's the leap in logic that the court sort of made for the Commonwealth. And again, I want to be very clear, the utmost respect for Judge Velaki, a very esteemed and learned jurist, but today I think the Commonwealth's evidence was very thin, and we may have to file some motions.
During the hearing, you pretty clearly pointed out that the deceased was a much larger man than your client. Do you intend to pursue a self-defense defense as you move forward in the trial?
Well, I tell you, one thing we can't deny is that Mr. Durham is deceased. Everything else is in contention. Everything else is in contention. The other piece that comes directly from Ms. Durham, my client's mother and the decedent's wife, is that they were fighting, or I think that she qualified it as scuffling. Mm-hmm. Well, when you see my client's height and weight, and then you talk about a 6'4", 300-pound individual, that sort of, I think you start to begin, and where the incident takes place. The incident took place in my client's bedroom. And he was thrust or ejected from the home, as one of the witnesses said, butt naked.
Right.
Now, you'd have to believe that my client provoked a fight with a 6'4", 300-pound man while he was naked in his own bedroom. You'd have to believe that to infer first degree. And that's why I say the Commonwealth's evidence today was extremely thin.
Sure. Two things that sort of came to light today for the first time, but that they were confirmed. They were sort of discussed before, but never confirmed, were the points that you just mentioned, that your client was forced from the home naked. He was naked when he first left the home, and also it also came out today that there were other firearms in the home at the time of the fight. So those are two, I think, important facts that weren't known before that sort of reveal some of the circumstances.
Well, and you have to sort of look at the placement of the Commonwealth's objections. Every time I started to sniff around other firearms, there was an objection, and Detective Silberto, who's a very fine detective, and he plays by the rules. He didn't play, hide the ball. He was very candid. There were other firearms in the home. Now, the interesting part is Ms. Durham, who sort of is the 911 caller, the mother, is very interesting that she was pretty emphatic that she was aware that there were no firearms in her house. Mm-hmm. However, there were firearms found in her very bedroom.
Sure.
So you have to ask yourself, as this case starts to shape up, where people's allegiances are. And it just saddens me that he's held on a first-degree murder, a young man who ultimately turned himself in, a kid who worked at Wawa, preparing to go to senior week the very next morning in Ocean City, Maryland, finds himself now bound over for court on first-degree murder charges under these facts.